Red Springs, North Carolina. September 11th, 1983. The town was small enough that everyone recognized every passing car, small enough that sirens carried weight, small enough that a single crime could fracture the illusion of safety overnight. That morning, the body of 11-year-old Sabrina Bowie was found in a soybean field. She had been brutally assaulted and murdered. News spread fast. Fear spread faster. In a town like Red Springs, tragedy does not stay private. It becomes communal. It becomes personal. It becomes urgent. There was grief, then anger, then pressure on law enforcement, pressure on the sheriff, pressure on anyone with a badge to make the fear stop. Because fear does not tolerate uncertainty, and uncertainty is exactly what investigators had. There were no reliable eyewitnesses placing anyone at the scene, no fingerprints conclusively tying a suspect to the crime, no DNA technology available at the time that could definitively identify a perpetrator. The physical evidence was limited, fragile, and inconclusive. But there was something else. Two young black men living nearby, quiet, different, vulnerable. Henry McCollum was 19 years old. His half-brother Leon Brown was 15. They were poor. They had intellectual disabilities. They had grown up in a world that did not protect boys like them. Henry's cognitive functioning would later be measured at a level comparable to a child. His IQ fell between 50 and 60. That meant abstract. Reasoning was difficult. Complex consequences were hard to grasp. Authority figures were intimidating. And in September 1983, Henry was taken into an interrogation room. Interrogation rooms are not designed for comfort. They are designed for control. Small spaces, artificial light, no clock, no sense of time passing, no window to orient yourself to the outside world. Henry sat inside that room for hours. There was no attorney beside him, no parent, no advocate, no psychologist to evaluate whether he understood what was happening. No recording capturing every word spoken. What we know about that interrogation comes from what was written afterward, from summaries, from reports, not from footage, and that absence matters, because interrogations are psychological environments. They are not neutral spaces. They are engineered encounters. Investigators ask questions in ways that imply answers. They suggest possibilities. They confront. They repeat. They apply pressure. For someone with average cognitive functioning, that pressure is intense. For someone like Henry McCollum, it can be overwhelming. Research now shows that individuals with intellectual disabilities are significantly more susceptible to suggestion. They are more likely to agree with leading questions, more likely to change their answers to satisfy authority, more likely to confess falsely if they believe it will end the interrogation. But in 1983, that research was not widely integrated into policing practices. So Henry was questioned. Imagine being 19 years old, with limited understanding of legal consequences, sitting in a room where grown men in uniform insist that that you were there, that they already have information, that the evidence points to you. They repeat details. They describe scenarios. They imply that cooperation will help. What does help mean to someone with an intellectual disability? It can mean, you get to go home. It can mean, the questions stop. It can mean, you did what they're saying, and it's easier to agree. Hours passed. Eventually, Henry signed a confession, a written statement that described involvement in the crime. But even that document raised questions. The narrative inside it did not match perfectly with forensic findings. Some details were inconsistent. Certain descriptions did not align with the medical examiner's conclusions. Parts of the statement appeared to contain information that would have been known primarily by investigators. And yet, a signature at the bottom changes everything. Because in a courtroom, a confession carries enormous weight. It feels definitive. Jurors are told people do not confess to crimes they did not commit. But that statement is not empirically true. False confessions happen. They happen more often than people realize, especially among juveniles, especially among people with cognitive impairments, especially in high-pressure cases involving public outrage. After Henry signed, Leon Brown also provided a confession. He was 15, also intellectually disabled, also interrogated without full protection. 2 confessions. The town had what it wanted. The uncertainty could end. Charges were filed. The case moved forward. In the courtroom, the prosecution presented the confessions as central evidence. The narrative was simple. 2 young men lured a child, committed a horrific act, and then admitted it. The defense attempted to highlight inconsistencies, but the absence of recorded interrogation meant there was no direct way to demonstrate coercion. Jurors heard that Henry confessed. That was enough. In 1984, Henry McCollum was convicted of rape and murder. He was sentenced to death. Death. A 19-year-old with the cognitive ability of a child was placed on death row in North Carolina. The legal system had delivered its verdict. The town could breathe again. There was closure, or at least the appearance of it. But something critical had not been examined deeply enough. Whether Henry truly understood what he had confessed to, whether he understood that signing that paper meant he could be executed, whether the confession reflected memory or compliance. Death row is not simply imprisonment. It is anticipation. It is waiting under the shadow of execution. It is isolation. It is years of appeals and uncertainty. Henry entered that environment still trying to comprehend what had happened. Meanwhile, the investigation effectively stopped. When police obtain a confession, especially in a high-profile case, the incentive to pursue alternative suspects diminishes. The narrative feels complete. But complete narratives can be dangerously deceptive. In the years following Henry's conviction, advances in psychology continued to reveal the vulnerabilities of certain populations during interrogation. Studies documented how suggestibility, compliance, and the desire to escape stressful situations contribute to false confessions. Interrogation techniques, such as the Reed technique, widely used at the time, encouraged psychological strategies designed to elicit admissions. Officers might present false evidence, suggest leniency, imply inevitability. For someone like Henry, those tactics are not simply persuasive. They are overpowering. And yet, at the time of his trial, the idea that someone would falsely confess to such a brutal crime seemed counterintuitive to many jurors. Why would anyone admit to something so horrific? The answer lies not in guilt, but in vulnerability. People with intellectual disabilities often struggle with long-term thinking. The immediate goal becomes ending the discomfort, ending the questioning, ending the confrontation. If confessing appears to achieve that, it can feel rational in the moment. But once the confession is signed, the system shifts gears. The interrogation room becomes a courtroom, the questions become accusations, and the signature becomes evidence. Henry's case moved into the appeals process, as all death penalty cases do. But appeals are complex. They rely on procedural arguments, on constitutional claims, on standards of review. They do not easily revisit the fundamental question of factual innocence unless new evidence emerges. And in 1983, there was no DNA testing sophisticated enough to definitively identify biological material from crime scenes. So Henry waited. He spent years inside a cell, measuring roughly 6 by 9 feet. Years marked by routine. Years defined by uncertainty. Years listening for footsteps that might signal execution dates. The town outside moved forward. Children grew up. Businesses opened and closed. The field where Sabrina Bowie had been found returned to normal seasonal cycles. But inside the prison, time froze. The confession remained the pillar of the case. Yet confessions are only as reliable as the conditions under which they are obtained. And the conditions under which Henry's confession was obtained were deeply flawed. No full recording, no attorney present, no documented assessment of cognitive ability before interrogation, no safeguards ensuring comprehension. Those omissions would become critical decades later. But in 1984, they were not enough to stop a conviction. The story seemed resolved. A crime, 2 confessions, a sentence. On the surface, it appeared simple. But beneath that surface, cracks were already forming. Because confessions are powerful, but they are not infallible. And sometimes the most dangerous evidence in a courtroom is not a weapon, not DNA, not eyewitness testimony. It is a piece of paper signed by someone who did not understand what it meant. Henry McCollum's name would later become synonymous with one of the most disturbing wrongful conviction cases in modern American history. But in that moment, in that small interrogation room in 1983, he was just a vulnerable young man trying to make the pressure stop. And the system interpreted compliance as guilt. The confession ended the investigation. It ended the town's uncertainty. It ended the search for alternatives. But it did not end the truth. The truth was still out there, waiting, because the real story was never in the confession. It was beneath it, and no one was looking under the surface. For years, the case appeared settled. 2 young men had confessed, a jury had convicted, a judge had sentenced. The system had delivered what it considered justice, a conclusion. But conclusions built on confessions can be dangerously fragile. After Henry McCollum and Leon Brown were convicted, the investigation effectively stopped. When law enforcement secures a confession, especially in a high-profile case, the urgency to pursue alternative leads often disappears. The narrative hardens. The search narrows. Doubt fades. In Red Springs, the town exhaled. There was grief, yes, but there was also relief. Someone had been held responsible. The terror had a name. The system had acted. But beneath that relief, evidence remained. Physical evidence collected in 1983 was preserved. Biological material, forensic samples, fragments taken from the victim's body. At the time, forensic science was limited. DNA testing as we know it today did not exist. Many cases from that era relied heavily on eyewitness testimony, circumstantial evidence, and, most powerfully, confessions. And so, the evidence sat, boxed, stored, archived, while Henry lived in a 6-by-9-foot cell on death row. Death row is not simply a prison unit. It is a psychological space suspended between life and execution. Years stretch, appeals crawl, every sound in the corridor carries weight. Henry spent decades inside that environment. He entered as a teenager with limited cognitive understanding. He aged under fluorescent lights, under institutional routine, under the shadow of lethal injection. Meanwhile, the world changed. Forensic science advanced. DNA profiling emerged as one of the most powerful investigative tools in modern history. Cases once considered airtight began to unravel. Across the United States, convictions were overturned when biological evidence told a different story than courtroom narratives. Organizations dedicated to reviewing questionable convictions began to grow. Innocence. Projects started examining cases where confessions seemed inconsistent, coerced, or unsupported by physical evidence. Henry McCollum's case stood out for several reasons. He had intellectual disabilities. He was interrogated for hours without a recorded transcript. The conviction relied heavily on confession. There was no strong physical evidence tying him to the scene. Attorneys began pushing for DNA testing on preserved biological samples from the crime scene. The request was not simple. Post-conviction testing often faces resistance. Prosecutors may argue that the verdict was already reached, that the confession stands, that reopening cases threatens finality. Finality is important to the justice system. It represents closure, stability, institutional confidence. But finality can also protect error. When testing was finally approved decades later, the results were definitive. The DNA found on the victim's body did not belong to Henry McCollum. It did not belong to Leon Brown. It belonged to another man, Roscoe Artis. Artis had lived near the crime scene in 1983. He had a history of violent offenses. Years after Sabrina Bouillet's murder, he was convicted of another brutal killing. But in 1983, once Henry and Leon confessed, Artis was no longer the focus of serious scrutiny. This is where cognitive bias becomes lethal. When investigators believe they have solved a case, they unconsciously filter new information through that belief. Alternative suspects become peripheral. Doubt is interpreted as noise. The confession ended the search. The DNA restarted it. And when the genetic evidence was matched to Roscoe Artis, the implications were staggering. The system had not merely made a procedural mistake. It had condemned the wrong person to death and allowed the likely true perpetrator to remain free for years. DNA evidence does not whisper. It does not suggest. It excludes. The probability calculations associated with forensic DNA leave little room for ambiguity. The material recovered from the crime scene matched Artis to a statistical certainty. It excluded Henry completely. 30 years of confinement, 30 years of death row, 30 years of appeals, 30 years of being labeled a child rapist and murderer, all built on a confession. When the DNA results emerged, the legal process did not immediately collapse the conviction. Courts had to review filings, motions had to be argued, evidence had to be formally evaluated. But the weight of the science could not be ignored. In 2014, Henry McCollum was officially exonerated. Leon Brown was exonerated as well. The courtroom that had once pronounced death now acknowledged innocence. The language shifted dramatically. Convicted murderer became wrongfully convicted and became false confession. Henry walked out of prison after 3 decades. The world outside was unrecognizable. Technology had transformed society. Phones were now handheld computers. Cars were different. Cities felt larger. The rhythms of life had changed. He had entered prison as a teenager with developmental limitations. He exited as a middle-aged man carrying institutional scars. Freedom, in cases like this, is not cinematic. There is no swelling music. There is adjustment, disorientation, trauma, media attention, public apology statements. North Carolina granted compensation, millions of dollars under state law for wrongful convictions. It was one of the largest payouts in the state's history. But compensation does not restore time. It does not restore youth. It does not erase the psychological damage of living under a death sentence. And there is something even more disturbing beneath the surface. While Henry sat on death row, Roscoe Artis committed another violent crime. He was later convicted of murder in an unrelated case. That means that while the system believed it had secured justice in 1983, it had actually left a dangerous individual free. This is the double tragedy of wrongful convictions. An innocent person loses decades of life, and the true perpetrator remains unaccountable. The justice system's reliance on confessions creates a dangerous feedback loop. Once a confession is secured, it becomes the lens through which all evidence is interpreted. Investigators may unintentionally ignore contradictions. Prosecutors may present narratives that appear cohesive because they are built around the admission. Jurors often view confessions as the strongest possible evidence. The assumption is intuitive. Why would anyone admit to a crime they did not commit? But that assumption collapses under psychological research. False confessions occur under certain predictable conditions: prolonged interrogation, intellectual disability, youth, suggestive questioning, promises of relief, threats of severe consequences. Henry fit several of those risk categories. The DNA did not create innocence. It revealed it. And once revealed, the system had to confront an uncomfortable reality. The safeguards that should have protected a vulnerable suspect were insufficient. There had been no full recording of the interrogation. Modern best practices now recommend video recording from start to finish. In some states, it is required. But in 1983, that protection did not exist. There had been no meaningful assessment of Henry's cognitive capacity before accepting his confession. There had been no lawyer present during questioning. Each omission compounded the risk. Yet, the trial proceeded. The conviction stood. And for decades, the confession remained the foundation of the case. When Henry was freed, reporters asked him how he survived 30 years under sentence of death. He did not give philosophical answers. He spoke simply about faith, about endurance, about trying to understand something that never made sense. There is something haunting about that, because the most devastating aspect of this case is not just the error, it is the duration. 30 years is long enough for a person to build an entire life. Instead, Henry built survival, and it all traces back to a room without windows, to pressure, to suggestion, to a signature. The DNA forced the system to reverse course, but it also exposed how fragile certainty can be when it is built on confession alone. The surface story in 1984 was simple: a crime, an admission, a conviction. But beneath that simplicity lay unanswered questions, overlooked suspects, unexamined evidence. The truth did not change over time. Only our ability to detect it did. And that is what makes this case so unsettling. Because if science had not advanced, if biological evidence had not been preserved, Henry McCollum might still be on death row today. Or worse. The confession closed the case. The DNA reopened it. And what it revealed was not just innocence. It revealed systemic vulnerability, a system that mistook compliance for guilt, a system that prioritized closure over certainty, a system that stopped looking once it found a narrative that worked. But this story does not end with exoneration, because Henry McCollum is not an isolated anomaly. He is part of a pattern, and patterns point to structures. In the final block, we move beyond the individual case, beyond Red Springs, beyond one interrogation room, because the deeper question is not simply how one man was wrongfully convicted, it is why the conditions that made it possible still exist, and whether the justice system has truly learned from what happened. Because sometimes the most dangerous evidence is not forensic, it is a confession. And sometimes the real story is not in what was said, it is in how it was extracted and why no one questioned it soon enough. Because the truth was never on the surface, it was buried beneath it, waiting. Henry McCollum's story is not only about a false confession, it is about what happens when a justice system prioritizes resolution over certainty. When Sabrina Bouyer was murdered, Red Springs demanded answers. Small towns do not tolerate ambiguity well. Tragedy disrupts identity. It threatens the belief that violence belongs somewhere else. Law enforcement felt that pressure. Prosecutors felt it. The community felt it. And when pressure builds, the focus subtly shifts. It stops being who committed this crime and becomes how do we prove we've solved it? Confessions provide relief. They create narrative closure. They restore a sense of order. But closure and truth are not the same thing. The system is built on the assumption that certain safeguards prevent catastrophic error. The right to counsel, the right to remain silent, the presumption of innocence, the adversarial process. But safeguards only work if they are meaningfully applied. Henry McCollum was intellectually disabled. That fact alone should have triggered heightened protections, psychological evaluation, legal presence during questioning, scrutiny of interrogation methods. Instead, he was questioned for hours without full documentation. There was no complete video record, no independent oversight. In modern criminal justice reform discussions, recording interrogations is considered essential. Many states now require it. The rationale is simple. Transparency protects both suspects and investigators. If Henry's interrogation had been fully recorded, would a jury have interpreted the confession differently? Would they have seen hesitation, confusion, suggestion, leading questions? We will never know, because the most critical part of the process was never preserved, and that absence protected the confession. False confessions are not rare anomalies. They have been documented repeatedly in wrongful conviction cases. According to studies of DNA exonerations in the United States, a significant percentage involve false admissions of guilt. Why? Because interrogation is not merely questioning. It is psychological strategy. Officers are trained to detect deception. They are trained to apply pressure. They are trained to secure admissions. The problem arises when the subject is highly vulnerable. Individuals with intellectual disabilities are more likely to agree with authority figures, struggle to understand long-term consequences, confuse hypothetical scenarios with reality, seek immediate relief from stress. In an interrogation room, that vulnerability can be catastrophic. Henry did not confess because he understood the weight of murder. He confessed because he was trapped in a psychological environment he could not navigate. But once the confession existed, the system treated it as reliable. Jurors are rarely experts in cognitive impairment. They rely on what seems intuitive. And intuition says people don't confess to crimes they didn't commit. That intuition is upper powerful. It overrides doubt. It overrides inconsistencies. And once a confession is presented in court, everything else bends around it. This is known as tunnel vision. Investigators narrow their focus to evidence that supports the confession. Contradictions are minimized. Alternative suspects are deprioritized. Roscoe Artis was not invisible in 1983. He was nearby. He had a record. He had proximity. But once Henry and Leon confessed, Artis faded into the background. The system had what it needed, or what it believed it needed. When DNA testing decades later identified Artis as the likely perpetrator, it exposed more than a wrongful conviction. It exposed structural weaknesses, the absence of mandatory interrogation recording at the time, the failure to account for cognitive impairment, the over-reliance on confession evidence, the difficulty of reversing a conviction once secured. Appeals courts often defer to trial outcomes. They examine procedural errors, not necessarily factual innocence. Once a jury has spoken, undoing that verdict becomes legally complex. Finality is valued, but finality can protect injustice. Henry's exoneration required not only science, but persistence. Lawyers who continued pushing, advocates who believed something was wrong, preservation of biological evidence that could have easily been discarded. If any one of those elements had failed, Henry might still be incarcerated or executed. That reality is not hypothetical. It is structural. The death penalty adds another layer to this story. Capital punishment assumes a level of certainty that human systems rarely achieve. It assumes that the investigative process, prosecutorial decisions, defense representation, jury deliberation, and appellate review together eliminate catastrophic error. But Henry McCollum was sentenced to die, and he was innocent. That fact alone destabilizes the assumption of infallibility. In 2002, the United States Supreme Court ruled in Atkins v. Virginia that executing individuals with intellectual disability violates the Eighth Amendment's prohibition against cruel and unusual punishment. But Henry had already spent years on death row by then. Even with that legal protection, he remained incarcerated until DNA evidence forced his release, which raises a profound question. How many protections exist only on paper? The justice system is composed of human beings, police officers, prosecutors, judges, jurors. Human beings are susceptible to bias, to pressure, to cognitive shortcuts, to emotional reaction. When a child is murdered, emotion runs high. The desire for resolution intensifies. Under those conditions, confession becomes a stabilizing force. It transforms chaos into narrative. But narrative is not proof, and proof requires scrutiny. The compensation Henry received after his release was among the largest in North Carolina history, millions of dollars awarded for wrongful imprisonment. But compensation does not measure psychological trauma. It does not account for 3 decades spent under a death sentence. It does not quantify lost relationships, lost opportunities, lost youth. Freedom after 30 years is not restoration. It is survival beyond injustice. There is another layer beneath this case: public trust. The justice system depends on public confidence. Confidence that police investigate thoroughly, that prosecutors pursue truth, not just convictions, that courts correct error. Wrongful convictions erode that trust. But they also reveal something important. The system is capable of error on a scale that is life-altering. And if it can happen in a capital case, where scrutiny is theoretically highest, it can happen anywhere. Henry McCollum's case is often cited in discussions of criminal justice reform. It is referenced in debates about interrogation practices, in conversations about the death penalty, in studies of false confession psychology. But beyond academic analysis, it represents something deeply human. A vulnerable teenager sat in a room with authority figures and tried to make the pressure stop. The system interpreted that compliance as guilt. 30 years later, science corrected the record. But correction does not erase origin. The real danger lies in the assumption that such cases are rare. They are not frequent enough to be statistically common. But they are frequent enough to demand structural reform. Mandatory recording of interrogations, special protections for cognitively impaired suspects, independent review of confession-based convictions, preservation of biological evidence. These are not luxuries. They are safeguards against irreversible harm, because once a confession is secured, it is incredibly difficult to dismantle, even when it is wrong. Henry McCollum's story forces an uncomfortable recognition. The justice system is not designed to handle vulnerability well. It is adversarial. It is pressure-based. It rewards resolution. But truth requires, and patience is not always compatible with urgency. Red Springs wanted a resolution in 1983. It got one. But it was the wrong one. The surface story made sense. A crime, a confession, a conviction. But beneath that surface, there were gaps, overlooked suspects, psychological fragility, structural blind spots. The truth was not visible because the system stopped looking, and when it finally resurfaced, it did not come through confession. It came through evidence. Evidence that could not be pressured, coerced, or manipulated by suggestion. DNA does not confess. It identifies. And in identifying Roscoe Artis, it revealed something larger than individual innocence. It revealed the cost of premature certainty. Henry McCollum survived 30 years on death row. Not because the system worked, but because science advanced in time to expose its failure. His case stands as a warning, not about one interrogation room, not about one prosecutor, not about one jury, but about what happens when a system prioritizes closure over caution. Because sometimes the most convincing evidence is the most fragile, and sometimes the loudest proof is built on silence. The silence of a room without cameras, the silence of a vulnerable suspect trying to comply. The silence of a system that stopped questioning once it had an answer. Henry McCollum's name now appears in law textbooks, reform panels, and policy debates. But at its core, his story remains simple. A confession was taken. It was believed. It was wrong. And it nearly cost a man his life. Because the real story is never on the surface. It's under the surface.